share my screen again. Okay, so let's continue. Let's go to alternative obligations and facultative obligations and solidary obligations. For alternative obligations, it's under Article 1199. A person alternatively bound by different prestations shall completely perform one of them. Okay, so that's alternative. You meaning either one of them will extinguish the obligation, the fulfillment or the fulfillment of the debtor of any of the obligations in alternative will extinguish. So a person alternatively bound by different prestations shall completely perform one of them, any one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. So it should be completely performed by of any one of them. So you cannot give partial of one item and then partial of another item if it is an alternative obligation. Okay. So we also have kinds of obligations according to the object. Simple obligations would mean there is only one prestation. Compound obligation means there are two or more prestations. Okay, it may be conjunctive or distributive obligation. When you say conjunctive, this was mentioned in the previous meeting, one where there are several prestations and all of them are due. Several, there is more than one, or there are more than one prestations. And distributive obligation, one where one of two or more of the prestations is due. It may be alternative or facultative. Okay. So in alternative obligations, it's where various prestations are due, but the performance of one of them is sufficiently determined by the choice, which, as a general rule, belongs to the debtor. So one of them in alternative. So meaning you can just perform or give any one of the obligations and extinguishes all the obligation. So example, you can give me $5,000 or give me your BMW or give me your house and lot. Okay, so if that's or if you promised me to give either $5,000 house and lot or your BMW car, okay, any one of those will extinguish the obligation. So if you give the BMW car, that extinguishes all the other obligation. That's an alternative obligation. If you give the house and lot, it extinguishes the obligation. You do not need to give the $5,000 or the BMW car. Okay, so it's something like that for alternative obligations. Okay, and it's usually the option of the debtor. The choice belongs to the debtor. For example, D borrowed from C 10,000 pesos. It was agreed that D comply with his obligation by giving C 10,000 pesos or a colored television set or by painting the house of C. So three obligations can be demanded. Either of those three obligations, the 10,000 pesos, the colored TV set, or the painting of the house, can extinguish the obligation. So the delivery of the 10,000 pesos or a color of TV set or the painting of the house is sufficient to comply with the obligation. Notice here the word used is or. Okay, or. So, performance must be complete. So, hindi pwedeng half ng 10,000 tapos half, magpipaint siya ng half ng house. No. It should be complete. Okay? The performance must be complete. C cannot be compelled. The creditor cannot be compelled to accept, for instance, 5,000 and a half of the television, thereby establishing a co-ownership between them, or 5,000 and the painting of part of the house. No. It should be complete of either one of them. Either it's the complete 10,000 pesos, or it's just the color TV set, or the painting of the entire house. Okay, so that's alternative obligation. So, for Article 1200 or 1200, the right of choice belongs to the debtor unless it has been expressly granted to the creditor. In alternative obligations, general rule, it belongs to the debtor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Of course, the only disclaimer or caveat here is that you cannot choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Hindi ka pwedeng magbigay ng or mag-fulfill ng obligation with a prestation na hindi naman napag-agrihan. Of course, any of those alternative that was initially agreed, and hindi rin pwede na impossible, unlawful yung prestation mo. Okay? So, the right of choice as a rule is given to the debtor. Okay? And by way of exception, it may be exercised by the creditor, but only when expressly granted to him under Article 1205, or by a third person when the right is given to him by common agreement. So, as a general rule, kung wala namang pinag-usapan, it's always the debtor who will choose which of the obligations he will comply. But if it is expressly granted to the creditor in the contract, then it can be the choice of the creditor. Or it could also be the choice of a third person if it is also expressly agreed upon by both parties previously. Okay? So, examples, D insured his house with R, an insurance company. It is agreed that if the house is destroyed or damaged, R may either pay the damage or loss, or reinstate or build or rebuild the house. Since nothing is said in the contract as to who has the right of choice, it belongs to R, the insurer, okay? The insurance company as the debtor, kasi siya yung magko-comply. Okay? So, wala siyang statement kung sinong mamimili. So, ang mamimili, by default, under the law, it will be the debtor. In this case, the debtor becomes R, the insurance company. So, siya yung mamimili. Next, S binds himself to deliver item 1 or 2 to B on November 10 and to communicate his choice on or before November 5. If S delays in making his selection, B cannot exercise the right because it is not expressly granted to him. But judgment in the alternative cannot be defeated by S by refusing to make a choice. In such case, the court can give the right of choice to B. So, ano dito sa example na to? S, okay, himself binds himself to deliver the item 1 or 2 to B. So, B is going to be the creditor, and it was expressly stated that B has the right to choose. Pero limited yung choice niya. It should be within November 5. Okay? Okay. If S delays in making his selection, okay, B cannot exercise the right because it is not expressly granted to him. Okay. So here S is the debtor and B is the creditor because it's the one who's going to receive either item 1 or 2. But S is only given up to November 5. But in this case, though, B cannot exercise the right as the creditor because it was not expressly granted to him. But the judgment in the and the alternative cannot be defeated by S by refusing to make a choice. So, di rin pwedeng i-delay na lang ni S kasi hindi siya mamimili. Dahil alam niyang hindi pwedeng mamili si B. The court here can intervene and give the right to choice to B. Okay? That was an exception. What about the right of choice that of the debtor that is not absolute? So the right of choice of the debtor is subject to limitations. One, the debtor cannot choose those prestations which are, as I've said, impossible, unlawful, or which could not have been the object of the obligation. So these prestations are void. Their presence do not invalidate the obligation if it includes other undertakings otherwise free from such defects. So ang magiging void lang yung impossible, illegal, or those that is not an object of the obligation. In other words, under Article 1200, the debtor's right of choice is not extinguished altogether, but limited only to the remaining valid prestations. Kung 5 yon, tapos 3 ang illegal or unlawful or impossible prestations, 2 na lang ang pagpipilian, the remaining valid prestations. Okay? So, the debtor has no more right of choice when among the prestations whereby he is alternatively bound, only one is practicable. So, kung sa 5 choices, 4 doon destroyed na o hindi na kaya or hindi na pwedeng i-deliver, then yung isa na lang talaga ang choice niya. So, parang nawala sa kanya yung choice. In this case, there is not only a limitation but a loss of the right of choice belonging to the debtor. The obligation becomes simple. Hindi na siya alternative because nawala na nga yung iba. So, the right does not pass to the creditor nor may it be exercised by anyone. So, hindi dahil nawala yung ibang choices in the alternative, magagrant yung choice kay creditor. No. The debtor simply loses the right to choose and therefore will only become an obligation that we call simple, which means there's only one prestation. Kasi na nga lang ang natira. Okay, another one, the debtor cannot choose part of one prestation and part of another prestation. I've already given that example earlier. Okay, Article 1201, the choice shall produce no effect except from the time it has been communicated. So, communication of notice, the choice has been made. So, the effect of notice, it becomes simple. Now, until the choice is made and communicated, the obligation remains alternative. But once the notice of the election has been given to the creditor, the obligation ceases to be alternative and becomes simple. Yung sinasabi ko, kung namili ka na, hindi na siya pwedeng mabawi because it becomes simple. It ceases to be alternative. Wala ka ng choices. You have already chosen. So, such choice, once properly made and communicated, is irrevocable and cannot therefore be renounced. Walang bawian. Such rule is inherent in the nature of the choice, its purpose being to clarify and render definite the rights of one exercising the choice so that the other party may act in consequence. So, ang reason kasi niyan, namili ka na and the other party may have already taken actions in relation to your decision. So, you can no longer change that. It's irrevocable. Okay? The concurrence of the creditor to the choice is not required. And hindi daw kailangan that the creditor will give its consent or concurrence because in the first place, kay debtor naman talaga naibigay yung right of choice. Okay? Where the choice has been expressly given to the creditor, such choice shall likewise produce legal effects upon being communicated to the debtor. In the same manner daw, kapag naman ang right of choice in the alternative obligation is given to the creditor hindi rin siya pwedeng bumawi or pawiin niya yung mga sinabi niya. So, yung example earlier, kung sinabing either 10,000 pesos or the color TV or paint the house, tapos expressly sinabi doon that the creditor has the right to choose. Pag sinabi ni creditor na, sige, muna akong bayaran ng 10,000 or bigyan ng color TV, you just paint my house. So, therefore, if it's properly communicated to the debtor, the obligation has become simple. To paint the house na lang. Wala na yung alternative to choose between the colored TV or the 10,000 pesos. It has become simple and cannot be revoked by the creditor. Hindi pwedeng sabihin ng creditor, kamulo ka nang nag-paint, sabihin niya, oy, pwede bang ano na lang, 10,000? Hindi ko na kailangan yung paint mo. Kailangan ko ng pera. No. Or, nakabili na si debtor ng pintura, even if he hasn't started painting yet, pero nandun na, di ba? So, you cannot just change as the creditor. So, the rules apply either to the creditor or the debtor. Once the decision has been made, the obligation ceases to become alternative and has now become a simple obligation. Okay? So, proof and form of notice. The burden of proving that such communication has been made is upon him who made the choice. Siyempre, kung ikaw yung namili, dapat meron ka evidence that you have particularly communicated to the other party. So the law does not require any particular form regarding the giving of notice. It may therefore be made orally or in writing, expressly or impliedly. So ngayon, medyo safe naman na and medyo mabilis na lang yung documentation. You can do a screenshot of your communication via text or chat or email. Right? It's safer kasi mahirap yung verbal or orally mo in-inform. How do you prove that? Unless meron ka witness, diba, that you actually communicated the choice. So the proof of notice is of course going to be the burden of the one who made the choice para i-prove niya that he actually gave the notice. Okay? In Article 1202, the debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. Ito yung sinabi natin kanina that if all the other items are no longer practicable or is no longer possible to deliver, then it will cease to be an alternative at magiging simple na lang. Kung ano na lang yung pwede niyang i-deliver. Okay, so effect when only one prestation is practicable. Under this article, the obligation is still alternative because the debtor still retains the right of choice. If only one is practicable, the obligation is converted into a simple one. Okay, so kung as long as meron pang choices, like kung 5 pero nasira na yung isa, it's still going to be alternative kasi meron pang other choices. Nasira yung 2 sa 5, meron pang 3 choices. Nasira yung 3, meron pang 2 choices. Pero kung 4 ang nasira of the 5 choices, isa na lang. So it ceases to be an alternative. Simple. So ito logic lang talaga to. Okay? Example, D borrowed from C 20,000 pesos. It was agreed that instead of 20,000 pesos, D could deliver item 1 or item 2 or item 3. If through the fault of C, item 1 is destroyed, D can rescind the contract if he wants. In case of rescission, the amount of 20,000 must be returned by D with interest. C, in turn, must pay D the value of item 1 plus damages. D, instead of rescinding the contract, may choose item 2 or 3 with a right to recover the value of item 1 with damages. If D chooses item 1, his obligation is extinguished. C is not liable for damages. Now again, D borrowed from C 20,000. It was agreed that instead of 20,000, D could deliver item 1 or item 2 or item 3. In this case, ang creditor natin is C. Okay? If through the fault of C, creditor, item 1 is destroyed, D can rescind the contract if he wants. So, pwede niyang i-rescind yung contract. In case of rescission, the amount of 20,000 must be returned by D with interest. Siyempre, dahil ipapa-rescind mo yung contract, isulit mo din yung pera. Okay? C in turn must pay D the value of the item 1 plus damages. Okay? Kasi siya yung nakasira through the fault of C. Above, no? Through the fault of C, item 1 is destroyed. D, instead of rescinding the contract, Kung ayaw niya naman ipa-rescind, okay, meaning the contract is still valid, may choose item 2 or 3 with a right to recover the value of item 1 with damages. Kasi isa lang naman ang mag-due, di ba? If D chooses item 1, his obligation is extinguished. Dahil ang nakasira naman, hindi niya na kailangang i-deliver yung item 1, sira na nga eh. But because si C ang nakasira noon, his obligation is automatically extinguished. C is not liable for damages kung ang pinili ni D is, in the alternative, is item 1. So, did you get this? Again, there are 3 items that will be due. Okay, item 1, 2, or 3. Kaya lang yung item 1 nasira dahil sa kasalanan ni C. So, what is going to be the remedy or the actions of D? The remedy could be that D can rescind the contract if you want. So, sabi niya, I want to rescind the contract because you acted at fault and in bad faith, and in your fault, you have destroyed item 1. So, in that case, kapag pinarescind niya yung contract, syempre, he needs to return the 20,000 kasi nakakuha mo siya ng 20,000. But must be returned with interest from the time when he actually got the 20,000. See, in turn, okay, dahil nakasira din siya, then isasolid niya yung value of the item 1 na nasira niya plus any damages suffered by D because of the item 1's damage or destruction, di ba? And then D, kung si D naman, sabihin niya, ay, hindi na yan ipaparescind ang contract. Instead, mamimili ako, okay? I will choose between 2 or 3, sabi ni D. So, pwede naman, okay? And it will still extinguish the obligation. However, D can also recover the value of item 1 kasi nga, kung magde-deliver pa siya ng item 2 or 3, doble ang damage ang loss sa kanya, di ba? Yung nawala pa sa kanya dahil na-destroy na item 1 or nag-deliver pa siya ng either 2 or 3. So in that case, kung magde-deliver siya ng 2 or 3, yung value ng item 1, kailangan ibigay din ni C. But if D, sabi niya, sige, para wala ng gulo, it's as if na lang pinili ko yung item 1. So pwede naman. So the obligation is extinguished at wala na rin damages si C. Okay? Kung pinili ni D is item 2 or 3, may damages na pwedeng i-claim si D from C. Dahil si C ang nakasera ng item 1. Tapos sabihin ni D, ay hindi ko pa naman choice yun na ibigay or i-comply sa obligation. Ang choice ko pa naman ay 2 and 3. So ito yung 3. Bibigay ko yung 3 pero bayaran mo ko sa item 1. Dahil ikaw yung nakasira nun. That's what this is. And this is an example, okay, under Article 1202. No? It will not cease to be an alternative obligation for as long as there are still choices. Pero kung lahat ng other choices is no longer practicable or has become lost or destroyed at isa na lang ang natira, it will no longer be alternative obligation. Magiging simple obligation na lang siya. Okay? Under Article 1203 naman, if through the creditor's acts, the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. Yung sinasabi natin dito sa example na to. Okay? When the debtor may rescind the contract, the rescission creates the obligation to return the things which were the object of the contract together with their fruits and the price with its interest. That's why dito, kung ipaparescind ni D yung contract, isusolid niya yung 20,000 plus the interest. The interest is the fruit. Okay? It is the very nature of an alternative obligation that the debtor can make his choice without the consent of the creditor. Hence, the right given to the debtor to rescind the contract and recover damages if, through the creditor's fault, he cannot make a choice according to the terms of the obligation. Parang sinasabi dito na tinanggalan mo ng right kasi si debtor kung nasira mo yung any of the alternative obligation. So the debtor, however, is not bound to rescind. Pwede lang din naman niyang hindi i-rescind yung contract. Okay? Under Article 1204, the creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. So in the same manner, kung sa kasalanan naman ni debtor, no, the indemnity shall be fixed taking as a basis the value of the last thing which disappeared or that of the service which last became impossible. So kung yung mga alternatives ay hindi na siya pwede or nawala na or na-destroy, okay, the last thing is going to be the basis. The last thing existing before everything ceases to exist or becomes possible is going to be the basis for the value. Damages other than the value of the lasting service may also be awarded, subject, of course, for the requirements of substantiation of the damages, actual proof of damages. So, effect of loss or becoming impossible of objects of obligation in 1203 and 1204. Okay, it apply when the right of choice belongs to the debtor. Under Article 1205, the creditor has the right to choose. Okay? So, if some of the objects, the obligation have been lost or have become impossible even through the fault of the debtor, the latter is not liable since he has the right of choice and the obligation can still be performed. Okay? If all of the objects, if all of them have been lost or have become impossible through the debtor's fault, the creditor has a right to indemnify, okay, or have right to indemnity for damages, since the obligation can no longer be complied with. Of course, if the cause of the loss is a fortuitous event, the obligation is extinguished. Again, we'll always go back to the principle that no person shall be responsible or liable for any fortuitous event. The phrase or the compliance of the obligation has become impossible refers to the obligations to do. Kung hindi niya na kayang i-perform, di ba? Ano ba yung hindi mo na kayang i-perform pero dati kaya mong i-perform? Kung dati kang singer, tapos na-operahan ka sa larynx, tinanggal yung ano mo, dahil nagkaroon ka ng cancer sa throat, hindi ka na pwedeng kumanta. So it has become impossible. So your fault, baka inoperahan ka dun sa throat mo dahil nasira dahil din sa kagagawan mo. So that's an impossible to do na. Okay? There's something like that. Example, S agreed to deliver. Another example, this is another example that we can look at. S agreed to deliver item 1 or item 2 or item 3. If item 1 is lost through the fault of S, he can still select either item 2 or item 3. The loss of item 1 and item 2 with or without the fault of S will reduce the obligation to a simple one. If all items are lost through his fault, liability will attach. If through a fortuitous event, the obligation will be extinguished. So, sorry na lang kung talagang fortuitous event ang reason ng pagkawala. Okay. But there are exceptions to that. We will get to the exceptions later. Basis of indemnity. The indemnity shall be fixed taking as a basis the value of the last thing which disappeared. Okay, sinabi ko kayo na, referring to the obligations to give, or that of the service which last became impossible. In case of disagreement, it is incumbent upon the creditor to prove such value, or which thing last disappeared, or which service last became impossible. Other damages may also be awarded. Okay, so in Article 1205, when the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Okay, so until then, the responsibility of the debtor shall be governed by the following rules. If one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. If the loss of one of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting or the piece of that which through the fault of the former has disappeared with a right to damages. So ito lang tricky kasi nga binigay yung choice to the creditor. So the creditor can still choose that which has disappeared. Pero kung kayo nang pinili niya, magkakaroon ng damages. Okay? Pero kung yung pinili niya dun sa remainder, walang damages. Okay? So, if all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any one of them, also with the indemnity for damages. Kasi hindi na pwedeng i-fulfill yun dahil nga it's lost or has become impossible to perform. The same rules shall be applied to obligations to do or not to do in case one, some, or all of the prestations should become impossible. Okay? So, where right of choice belongs to creditor in alternative obligations, as a rule, it belongs to the debtor. But, the debtor may expressly give the right of choice to the creditor, as stated in Article 1200. In such a case, the provisions which, with respect to the debtor, are laid down in the preceding articles shall be applicable to the creditor when the right of choice is given to him. So, kung ano yung rights ni debtor being the one who has the right of choice, will also be the right of the creditor if the right of choice is given to the creditor. Okay? Before the creditor makes the selection, the debtor cannot incur any delay. What are the rules in case of loss before the creditor has made choice? When a thing is lost through a fortuitous event, okay? Example, S obliged himself to deliver to B item 1 or item 2 or item 3 or item 4. If item 1 is lost through a fortuitous event, B can still choose from among the remainder or that which remains if 3 of the items are lost. Okay? When a thing is lost through a debtor's fault, okay, so kung ito naman, hindi siya fortuitous event, ang loss is dahil sa kasalanan ni debtor. If the loss of one item occurs through the fault of S, B may claim item 2 or item 3 or item 4 with a right to damages or the price of item 1, also with a right to damages. Okay? So always with damages kasi nga at fault si debtor, regardless of the choice. When all things are lost through the debtor's fault, ay ito malala, di ba? If all items are lost through the fault of S, then B can demand the payment of the price of any one of them, of item 1, 2, 3, or 4, with a right, of course, to the indemnity for damages. When all the things are lost through a fortuitous event, paano kung fortuitous event na nawala lahat? The obligation of S shall be extinguished if all the items which are alternatively the object of the obligation are lost all through a fortuitous event. Okay? So, basta fortuitous event, okay, general rule, you will not be liable for damages and the obligation is extinguished. But if it's through the fault, okay, of the debtor, meron yan damages. Basta may fault. Okay. Rules applicable to personal obligations. The above rules are also applicable to personal obligations. The responsibility of the debtor for damages depends upon whether the cause which has rendered the obligation impossible was due to his fault or not. Okay. In Article 1206, okay, it says that when only one prestation has been agreed upon, but the obligor may render another in substitution, the obligation is called facultative. Facultative substitution. Okay? The loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. Okay? So, again, kung wala pa yung substitution, hindi pa nangyari, even if nag-deteriorate yung thing, okay, and even if it was through the negligence of the debtor, hindi pa siya liable nun. Pero kung nangyari na yung substitution, Yung sinasabi dito, once the substitution has been made, the obligor is liable for the loss of the substitution on account of his delay, negligence, or fraud. Okay? So what is facultative? Again, a facultative obligation is one where only one prestation has been agreed upon, but the obligor may render one another in substitution. Let's look at an example. I will give you my piano, but I may give my television set as a substitute. In this obligation, only one piano is due. Hence, its loss through my fault will make me liable. Okay? So, I will mortgage my land to secure my debt, which shall be payable within 90 days upon my failure to pay my debt within 30 days. Here, I may mortgage my land in substitution of the obligation to make payment within 30 days. Okay, so again, I will mortgage my land to secure my debt, which shall be payable within 90 days upon my failure to pay my debt within 30 days. So, the mortgage of my land in substitution of the obligation to make payment within 30 days is a substitute. No? So, before substitution, if the principal thing is lost through a fortuitous event, the obligation is extinguished. Otherwise, the debtor is liable for damages. The loss of the thing intended as a substitute with or without the fault of the debtor does not render him liable. So, kung wala pang substitution na nangyari, kahit mawala yung substitute, ma-lost or ma-destroy, wala kang liability. Okay? The reason is that the thing intended as a substitute is not due. It's never due until you choose to substitute. Okay? The effect of the loss is merely to extinguish the facultative character of the obligation. It will cease to be a facultative obligation, and it will now have just one prestation and will therefore just call it a simple obligation. What happens if it happens after substitution? Yung loss nangyari after substitution. If the principal thing is lost, the debtor is not liable whatever may be the cause for the loss because it is no longer due. Tapos na yung substitution. After the substitution, it ceases to be a facultative obligation as well. It now becomes a simple obligation with just one prestation, which is the substitute. If the substitute is lost after the substitution, the liability of the debtor depends upon whether or not the loss is due through his fault. If it's through his fault, of course, he is liable for the value of the thing that was lost plus damages. Okay? But if it's not his fault or through fortuitous event, the obligation is extinguished. So once the substitution is made, the obligation is converted into a simple one to deliver or perform the substituted thing or prestation. The substitution becomes effective from the time it has been communicated. So, pagka na-communicate mo na yung substitution, namili ka na, it ceases to be a facultative obligation. Hindi na siya pwedeng i-substitute kasi nag-substitute ka na or namili ka na to substitute. So, it ceases to be a facultative, it now becomes a simple one. Isa na lang ang prestation ngayon. Yun na yung pinili mo na substitute. If that substitute is lost after you have done your substitution, you will be liable for the value of the thing you lost as a substitute plus damages. If it is your fault, negligence, or fraud. But if it is through fortuitous event, the obligation is extinguished. Okay. So, what's the difference between alternative and facultative? I hope by now it's already clear what's an alternative obligation and what's a facultative obligation. Okay, so the differences are as follows. In the first, several of prestations are due, but compliance with one is sufficient. While in the second, only one prestation is due, although the debtor is allowed to substitute another. Okay. Right of choice. In the first, meaning in alternative, the right of choice is given to the creditor or third person, while in the second, the right to make the substitution is given only to the debtor. The right of choice may be given to the creditor or third person, while in the second, the right to make the substitution is given only to the debtor. Sa alternative, pwedeng magkaroon ng right of choice si creditor or third person. But sa facultative, only the debtor has the right to choose. For loss through fortuitous event, in alternative, the loss of one or more of the alternatives through a fortuitous event does not extinguish the obligation. Diba? Kasi nga, meron pang alternative. Okay? Remainder items or choices. While in the second, the loss of the thing due to fortuitous event extinguishes the obligation. Loss through the fault of the debtor. In alternative, the loss of one of the alternatives through the fault of the debtor does not render him liable. Again, because there are other choices. While in the facultative, the loss of the thing due through his fault makes him liable. In the first, meaning in the alternative, the choice belongs to the creditor. Okay? The loss of one alternative through the fault of the debtor gives rise to the liability, while the second, the loss of the substitute before substitution will not render, will not render the debtor liable. Nullity of prestation. In alternative, the nullity of a prestation does not invalidate others, while in the second, the nullity of the prestation agreed upon invalidates the obligation. In alternative, the debtor or creditor shall choose among the remainder, while in the second, the debtor is not bound to choose the substitute. Okay. So, in ordinary alternative obligations, a mere categorically and unequivocally made and then communicated by the person entitled to exercise the option concludes the parties. The creditor may not thereafter exercise any other option unless the chosen alternative proves to be ineffectual or unavailing due to no fault on his part. This rule, in essence, is the difference between alternative obligations on the one hand and alternative remedies upon the other hand, where in the latter, the choice generally becomes conclusive only upon the exercise of the remedy. For example, in one of the remedies expressed in Article 1482 of the Civil Code, it is only when there has been a foreclosure of the chattel mortgage that the vendee mortgager would be permitted to escape from a deficiency of liability. Thus, if the case is one for specific performance, even when this action is selected after the vendee has refused to surrender the mortgaged property to permit an extrajudicial foreclosure, that property may still be levied on execution, and an alia writ may be issued if the proceeds thereof are insufficient to satisfy the judgment credit. So also a mere demand to surrender the object which is not heeded by the mortgagor will not amount to a foreclosure, but the repossession thereof by the vendor mortgagee would have the effect of foreclosure. Okay, but we'll just this is just included here, but it's going to be a deeper study in the of obligations later on, if you're going to compare alternative obligations from alternative remedies. But in this sense, though, you have to remember that alternative obligation is different from alternative remedies. Okay, so what about joint and solidary obligation? Okay, so joint and solidary obligations under Article 1208 and 1207, the concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand or that each one of the latter is bound to render entire compliance with the prestations. There is a solidary liability only, underline mo yan, when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. So even if there's a lot of creditors or debtors, it does not automatically make them solidary. That's what 1207 means. And then 1208, if from the law or the nature of the wording of the obligations to which the preceding article refers the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors. The creditors or debtors being considered distinct from one another subject to the rules of court governing the multiplicity of suits. Okay, so joint and solidary obligations. So again, it has to be expressly stated that the obligation is solidary among the debtors, okay, or that the obligation is solidary among the creditors. We'll discuss the effects later on of whether it's solidary and joint. Okay. So kinds of obligation according to the number of parties. Individual obligation, one when there is only one obliger and one obligee. That's individual. Collective, meaning one where there are two or more debtors and or two or more creditors. Okay. Right, in a collective obligation, there are two relations involved, that between the creditor and between the debtors. Okay? Or the creditors and the debtor, or the creditors and the debtors. Okay? And that among the creditors and or debtors themselves. So let's define joint and solidary. Joint is one where the whole obligation is to be paid or fulfilled proportionately by the different debtors and or is to be demanded proportionately by different creditors. Okay. So if it's divided, no, proportionately, demanded proportionately, okay, by the different creditors, different debtors and different creditors. So it could be multiple creditors and multiple debtors, or multiple debtors but one creditor, or multiple creditors but one debtor. Okay, a solidary obligation is one where each one of the debtors is bound to render and or each one of the creditors has a right to demand entire compliance with the prestation. Sa solidary obligation, all or nothing, pwede kasing all or nothing. So, meaning, if you say solidary obligation siya, the creditors may demand from any one of the debtors the entire amount if they are solidary creditors and the debtors are solidary debtors. Okay, in the same way, the debtors can pay the entire amount to the creditors, okay, subject of course to reimbursement by the other debtors. So, sa joint kasi, talagang proportionately lang ang portion. So, the creditor, if the obligation is 100 pesos and there are 4 creditors, each creditor can only collect up to 25 pesos. Okay? If they are also joint debtors, each debtor can only be compelled to pay only 25 pesos each maximum. In solidary obligation, kung 100 pesos ang obligation, then there are 4 debtors. Any one of the 4 debtors can be obliged to pay the entire 100 pesos if they are solidary debtors. Okay? So, pwede siyang all or nothing na ano. Okay? So, that's why it's called solidary. Kung joint, it is proportionate. Okay? Proportionate and separate. Okay? So, characteristics, essence, and basis of a solidary obligation. Every solidary obligation has these characteristics. 1. Unity of object and plurality of ties. The prestation due or to which a right exists is one and the same thing. The essence of solidarity is that each and every one of the solidary creditors can demand, this sinasabi ko kanina, and each of the debtors must satisfy the same prestation with the resulting duty on the part of the creditor who received payment to pay to each of his co-creditors. Siyempre, kung siya yung nakakollect ng entire obligation, he has the duty to give what belongs to the other co-creditors. And the resulting right on the part of the debtor, kung siya naman lahat nagbayad ng entire amount ng utang, he is also entitled to collect or claim from his co-debtors the share which corresponds to each. Okay? The basis of solidarity in either case has something of a legal fiction. That it is a mutual among those interested in the same obligation. The solidary obligation is really a form of joint obligation. Okay? So, when obligation is solidary is not lightly inferred. Under Article 1207, there is solidary liability when 1. The obligation expressly states so and the law requires solidarity. The nature of the obligation requires solidarity. Okay, solidary liability also exists when it is imposed in a final judgment. Meaning yung court ang nag-decide. And against several defendants. That is solidary obligation. So these are the only instances where there will be a solidary obligation. Okay. Words used to indicate solidary liability. Okay, this is going to be very good for you to remember. It is not necessary that the agreement should employ precisely the word solidary in order that an obligation may be considered solidary. Okay, it is sufficient that the obligation declares, for instance, that each one of the debtors can be compelled to pay the entire obligation or can be proceeded against for the full amount of the obligation, or that demand may be made against any one of them. Those kinds of words will constitute solidary liability. Okay? So, kinds of solidarity according to the parties: passive solidarity or solidarity on the part of the debtors, where any one of them can be made liable for the fulfillment of the obligation. Its characteristics are plurality of debtors and unity of prestation. It is in the nature of the mutual guarantee. Meron din tayo active solidarity or solidarity on the part of the creditors. This one, where any one of them can demand the fulfillment of the entire obligation. Its essential feature is that a mutual representation among the solidary creditors with powers to exercise the rights of the others in the same manner as their rights. So, pwede silang mag-collect the entire amount pag solidary creditors sila, any one of them. Mixed naman kapag marami silang debtors and creditors and they are solidary, where each one of the debtors is liable to render and each one of the creditors has the right to demand entire compliance of the obligation. Okay? Klaro ang solidary and joint?
Sir. Yes, sir.
Okay. Next, according to source, conventional solidarity, or where solidarity is agreed upon by the parties. If nothing is mentioned in the contract relating to solidarity, the obligation is only joint. Again, because as expressly stated in 1207, we can only call an obligation solidary when it expressly says so, or when it is required by law, or when by the nature of the obligation it is not divisible. Okay? Legal solidarity, or where solidarity is imposed by law, and real solidarity, or where solidarity is imposed by the nature of the obligation. Then let's go to the joint indivisible obligation. Okay? If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the others shall not be liable for his share. Okay? So, joint indivisible obligation. This article speaks for a joint indivisible obligation. The obligation is joint because the parties are merely proportionately liable. It is indivisible because the object or subject matter is not physically divisible into different parts. In other words, it is as to liabilities of the debtors or rights of the creditors, but indivisible as to compliance. This obligation constitutes the middle ground between a joint obligation and a solidary obligation. Let's look at an example. Okay, A, B, and C are jointly liable to give D a car valued at 240,000 pesos. On the date of delivery, A and B are willing to deliver, but C is not. Okay? So, in this case, D has no cause of action against C for the delivery of the car because, as a joint debtor, C is liable only for a proportionate part of the obligation, which is 80,000. Since the object car is indivisible, the debt can only be enforced by proceeding against all the debtors for compliance is not possible unless they can act together. Di mo naman pwede kasing hawitiin yung car, no? So, kailangan talaga silang lahat. Okay? Pursuant to Article 1224, the liability is converted into one for damages. So, A, B, and C will be liable for 80,000 each or a total of 240,000, which is the value of the car, without increase of responsibility for A and B. C, the unwilling, yung hindi pa ready, the unwilling debtor shall be liable for damages to D for having violated the obligation. If A and B suffered damages for reason of the non-fulfillment by C, they may also recover from C. Masyado nang kawawa si C, no? Magre-recover ng damages si D sa kanya at pati si A and B magre-recover ng damages sa kanya. Should any one of the debtors be insolvent, the others shall not be liable for their share. D must wait until the insolvent debtor can pay. So kung insolvent si C in this case, mag-wait talaga siya until everyone is going to be able. Kasi nga, indivisible naman yung car. Hindi yung pwedeng hatiin. Dahil 160 pa lang ang pera namin, di ba? So, again, D must wait until the insolvent debtor can pay. Let's go to 1210. The indivisibility of an obligation does not necessarily give rise to solidarity. Itong example na to, it does not give rise to solidarity even if it is indivisible item, no? So yun sinasabi dito. Indivisibility, distinguished from solidarity. Indivisibility refers to the prestation, while solidarity refers to the juridical or legal tie that binds the parties. Okay? In indivisible obligations, only the debtor guilty of breach of obligation is liable for damages. Okay? Thereby terminating the agency, while in solidary obligations of all the debtors are liable for the breach of the obligation committed by a co-debtor for solidarity among them. For solidarity among them remains. Indivisibility can exist although there is only one debtor and one creditor. Okay? Pwede kasi yan, di ba? As we have discussed. While in solidarity, there must be at least two debtors or two creditors. Okay. In indivisible obligations, the others are not liable in case of insolvency of one debtor, while in solidary obligations, the others are proportionately liable. Again, indivisible obligations, the others are not liable in case of insolvency of one debtor, while in solidary obligations, the others are proportionately liable. Kasi nga, in solidary obligations, the solidary debtors can be compelled to pay the entire amount. Okay? So look at examples, scenarios. A and B are jointly liable to deliver to C a particular car. Here, the prestation is indivisible, but the liability of A and B is joint. Okay? We have what is called a joint indivisible obligation. If A and B oblige themselves solidarily to give car to C, we have a solidary indivisible obligation. Notice the difference. In the first example, the debtors are jointly liable. In the second, the debtors are solidarily liable. So both are indivisible because a car is an indivisible prestation. But in the first, it's a joint indivisible obligation. In the second, it's an indivisible, okay, solidary obligation. The obligation is indivisible and the liability of A and B is solidary. To put it in another way, we have a solidary obligation, the subject matter of which is indivisible. In case of breach, even the innocent debtors are liable for the entire indemnity without prejudice to their right of action against the guilty one. Meaning, pag hindi nakabayad yung A, si B will be liable for the entire amount. Or pagka hindi nakabayad si B, si A ang magiging liable for the entire amount. Okay? If there is damages claimed, the entire amount, including the claims of damages, will also be due. Of course, A, okay, who will pay the entire amount will also be entitled to recover from B, should B later on be capable of paying. Okay, another example, a solidary obligation does not necessarily mean that the obligation is also indivisible. Okay, it doesn't mean na dahil solidary ang debtors, indivisible na yung obligation. Thus, where A and B promised in solidum is also a term that we use to state that they are a solidary party to pay C 10,000 pesos. So here, the 10,000 pesos is divisible, right? But the debtors are solidary. So we have here a solidary divisible obligation. Now, if A and B are jointly liable to pay C 10,000 pesos, what we have is a joint divisible obligation. Notice this one with compare this one with the first example. In the first example, we have joint indivisible obligation, while in number 4 we have joint divisible obligation. So, just it's important that you understand what is joint and what is divisible, what is solidary and what is divisible or indivisible. Okay, solidarity does not automatically qualify the prestation as indivisible. In the same way, indivisibility of the prestation does not automatically vest solidarity of the parties. Okay, in the contract.
Sir, excuse me, sir.
Yes.
Sir. Sir, sa example number 3, sir, kay solidary divisible man siya, it's either A or B na pagyapo ng mag...
Either A or B can pay the entire amount of 10,000.
Sige, sir.
Yes. What is meant here in example 3 is that since it's a solidary divisible obligation, although the money which is 10,000 is divisible, pwede naman 5,000, 1,000, it is physically possible, right? So it is divisible. But because it is solidary, okay, C can compel either A or B. Pwedeng si A lang singilin niya for the entire 10,000. Pwedeng si B lang ang singilin niya for the entire 10,000 because they are in solidum. Whoever pays has the right to recover from the other. Okay, so kung si B ang nagbayad ng buong 10,000, pwede niyang singilin ng 5,000 si A. Or kung si A ang nagbayad ng entire 10,000, pwede niya rin singilin si B. Pero wala nang pakialam si C doon. Ang sa point ni C is, I need the 10,000 and I will demand it from either of you. You can both pay together in one payment of 10,000 or either of you can pay 10,000 and wala akong pakialam kung paano nyo i-recover from each other yung share ng isa. Okay? That is what solidary is. And in number 3, it is a solidary divisible obligation because money is divisible in nature. Ang kuha?
Kuha na, sir. Thank you, sir.
Okay. 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 Okay, so Article 1211, we have solidarity, which may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. So kinds of solidary obligation according to the legal tie, uniform or non-uniform or varied. When you say uniform, the parties are bound by the same stipulations or clauses, or non-uniform or varied when the parties are not subject to the same stipulations or clauses. So solidarity is not affected by diverse stipulations. Okay. The essence of solidarity consists in the right of each creditor to enforce the rights of all and the liability of each debtor to answer the liabilities of all. Therefore, there may be a solidary obligation although the parties may not be bound in the same manner and by the same periods and conditions. The rule is that the creditor may bring his action in toto against any of the solidary debtors less the shares of other debtors with unexpired terms or unfulfilled conditions who are entitled to defenses under 1222. So, joint obligation on one side, solidary on the other. An obligation may be joint on the side of the creditors and solidary on the side of the debtors or vice versa. Mas exciting to, di ba? So, hindi sila pareho. Okay? In such cases, the rules applicable to each subject of the obligation should be applied. The character of the creditors or the debtors determining their respective rights and liabilities. Okay? Thus, if the obligation is joint on the side of the creditors and solidary on the side of the debtors, each creditor can demand only his share in the obligation, but each debtor may be compelled to pay the entire obligation to the creditors. Okay. Um, for Article 1212, Act of Solidary Creditor useful or prejudicial to others. A solidary creditor may do any act beneficial or useful to the others, but he cannot perform any act prejudicial to them. If he performs such act and as a result the obligation is extinguished, he shall be responsible to the other for damages. As far as the debtor or debtors are concerned, the act shall be valid and binding. The rule is based on the theory of mutual agency among solidary creditors. A joint creditor cannot act in representation of others. Kung joint siya, wala rin siyang right to represent, okay, the others. Okay. A solidary creditor cannot assign his rights without the consent of the others. So, assignment by solidary creditor of his rights, meaning gusto niya ibang tao na mag-collect. Okay? In the absence of a consent given by the others, a solidary creditor cannot assign his rights to a third person. Hindi mo pwedeng ilipat. The reason behind this prohibition is that each creditor represents the others. Okay, there is agency kasi in here. The assignee may not have the confidence of the original solidary creditors, considering that the assignee, after receiving payment, may not give the shares of the others. Sa solidary creditors kasi, there is like mutual trust among each other. That's why they can represent each other in the um, collection or in compelling the debtors to fulfill the obligation. But if another person who is not part of the original obligation agreement will come in, you will not have the same confidence or trust in that person as you have in the original creditor. So, assignment by solidary creditor of his rights cannot be done without the consent of the others. Kailangan pumayag muna yung iba. Okay? The debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Okay? The debtor, again, may pay any one of the solidary creditors. Pero kung merong naningil, dun dapat siya magbayad. Okay? Payment to any of the solidary creditors. The rule is that the debtor may pay any of the solidary creditors. That's the rule. Pero kung may naningil, again, payment should be made to him. Otherwise, the obligation will not be extinguished except insofar as the creditor pays share, okay, is concerned in case the latter does not give to the other creditors their shares in the payment. The demand has the effect of terminating the mutual agency among solidary creditors. Once there is already a demand from any of the solidary creditors, okay, it ceases, okay, to have mutual agency among all other creditors. Meaning, you are now compelled or should be paying only to the one who made the demand. Okay. In 1215, novation, compensation, confusion, or remission of the debt made by any of the solidary creditors or any with any of the solidary debtors shall extinguish the obligation without prejudice to the provisions of Article 1219. So, here, if there are changes made by one of the solidary creditors, since he or she represents the entire group of solidary creditors, that will in effect, okay, extinguish the entire obligation. Liability of solidary creditor in case of novation, compensation, confusion, or remission, okay, are modes or causes of extinguishment of obligation. It is but logical that the creditor who executed any of these acts should be liable to the other solidary creditors, of course, si siya yung may kagagawan, no? Corresponding shares considering that the such acts are prejudicial to them. Basta kung meron nag-act in any of the creditors, kasi ang rule, di ba, when it's a solidary creditor, any one of them can collect. So if any one of them represents, okay, and do any of this, novation, compensation, confusion, or remission, that extinguishes the obligation. Of course, yung nag-extinguish, yung nag-act on novation, compensation, confusion, or remission, kung sino may makagagawa nun, syempre, he is also still liable to the share of the other creditors. Okay? Kasi it does not necessarily follow na dahil nag-act siya, alam na lahat ng ibang creditors na solidary. No. So, when the moment the other solidary creditors discover, they can recover from the one who made these acts of novation, compensation, confusion, and remission. Okay? So, an extension of time given, granted to by the creditor to a solidary debtor does not amount to a novation. That will discharge the other solidary debtors. The latter shall be liable for the whole debt less the share of the debtor granted the extension. Upon the expiration of the term, the creditor can demand payment of the unpaid share from any of the solidary debtors. So, meaning, kung marami kasi silang debtors, okay, and then one has been granted an extension, so at the time of the demand of the creditor, yun lang pwede niyang i-demand yung share ng due and demandable among the solidary debtors minus yung share ng debtor na nagranta ng extension. Kung 100 pesos yung obligation, apat silang may utang, solidary debtors, tapos one of the debtors is granted an extension, 75 lang muna ang pwedeng i-demand na entire amount. Until such time na mag-lapse yung date ng extension, then the entire amount can be demanded from any of the debtors. Yan yung sinasabi dito. Okay? The effects of novation where obligation is joint. If the obligation is joint and any other cause of modification or extinction does not extinguish or modify the obligation except with respect to the creditor or debtor affected without extending its operation to any other part of the debt or of the credit. So, ang kaibahan lang nito, hindi yung entire obligation will be extinguished. Only to the portion and to the share of the debtor-creditor who agreed on the novation, remission, compensation, okay, of and confusion acts of the affected parties. Okay, so Article 1216, the creditor may proceed. The creditor may proceed against any one of the following debtors, or some or all of them, simultaneously. The demand made against one of them shall not be an obstacle to those which may be subsequently directed against the others. So, so long as the debt has not been fully collected. Okay. So, the right of creditor to proceed against any debtor in the above provision is not applicable to a joint obligation. It reiterates the rule that in a solidary obligation, meaning passive solidarity, any one or some or all of the debtors simultaneously may be made to pay the debt, so long as it has not been fully collected. Since the liability is solidary, the other solidary debtors are not indispensable parties in a suit filed by the creditor. The bringing of an action against the solidary debtor to enforce preclude the bringing of another to compel the others to fulfill their obligations. A solidary debtor is also a surety. So, again if the bringing of an action against a solidary debtor to enforce preclude the bringing of another to compel to others. So, mamili ka din kung sinong kakasuhan mo. Okay? Because if you filed a suit against one of the solidary debtor, it precludes you to file another suit against another solidary debtor. So, syempre, pili mo yung medyo will take action and pay the obligation or siguro yung may bala, may pambayad, no? So, that's the gist there for this provision. In case of death of one of the solidary debtors, the creditor may proceed against the estate of the deceased solidary debtor alone or against any or all of the surviving solidary debtors. So kung may namatay dun sa solidary debtors, pwede mo pa rin i-compel yung namatay pero hindi na siya, kasi patay na siya. Sino yung compel mo? The estate of the deceased. Okay? Yung estate, meaning whatever remains is the properties, okay, assets of the person who's one of the solidary debtors who died. Or pwede ka rin maghabol dun sa buhay, the surviving solidary debtors whose liability is independent of and separate from the deceased debtor. Instead of instituting a proceeding for the settlement of the estate of the deceased debtor wherein his claim could be filed. Okay? Medyo matrabaho yun kung sa estate ka talaga mag-claim. It's like a long process. The choice is left to the solidary creditor to determine against whom he will enforce collection. Ito maganda kay creditor kasi mamimili siya, ano? And sa kanya naka-fall yung choice, okay? Siya yung may karapatang mamili kung kanino niya sisingilin, okay? Among the solidary debtors. Okay? 12:17. Okay. Maybe we can stop here para hindi naman ganun kadami. We'll stop here muna.